the time that we've got remaining, I'd just like to take a brief moment just to ask our panelists for their key takeaways or their final thoughts. John, you led us off this afternoon. Perhaps you want to be the first to close us out with a few of your key takeaways, and then Suzanne, over to you for a few of your final thoughts as well.
Oh, sure, thanks. I guess the main thing is to first understand that trade secret protection can be really essential to what you do, and that in certain industries like biotech, you may not be able to patent things and you'll really want trade secret protection. And the other takeaway is that you need to work with your lawyers to be proactive about it, because where you don't want to find yourself is something that's really valuable to you wasn't given sufficient trade secret protection, or you didn't have systems in place to present on an expedited basis the proofs you need to protect it, and you're really in a bad spot in a competitive marketplace. And the other side of being sued, just as we just talked about, and Suzanne explained it very well, is that you really want to be careful when you hire somebody or you go into a joint venture or whatever, that you have done the right thing so you will not be inaccurately perceived by a court as being a bad actor. This is something about which you need to think proactively, and the more that you do that, the better you'll be.
Yeah, and I would add to that, you know, I'm going to attempt to use an old saying here. I'm told I screw them up all the time, so if I screw this up, I'm really sorry. But I think there's an old saying about something along the lines of an ounce of prevention. I think that really applies here. I think what both John and I have really emphasized throughout this webinar is you have to take your steps up front. You have to protect your information with all reasonable means, and I think train and put all the right agreements in place, whether it's internal or external, and try to cover yourself as much as you can on the front end. And everything you do on that front end is going to benefit you if, unfortunately, a trade secret is misappropriated at a later date. And in this day and age, I think that it's more important than ever, because people will misrepresent themselves. Companies will send people in to misrepresent themselves in an effort to get your confidential information. They know it's going to be very valuable. So you may not prevent every situation from occurring, just like in that Epic case I talked about earlier. And that was a pretty sophisticated, fraudulent scheme that the competitor used to access the confidential information. Might it have been prevented? I think that if you look at all the facts, it could have been. It should have been perhaps this former person who had the access, that access should have been denied. Those credentials should have been taken away. But unfortunately for Epic in that situation, they didn't know all the backstory. And also, it was only, like I said, brought to light because there was a whistleblower at the competitor. But Epic in that situation had put in place layer upon layer upon layer of protection, which included agreements and in their license agreements with their customers, certain levels of protection, limited access, and of course confidentiality. So an ounce of prevention is really going to go a long way toward protecting you in the unfortunate event something is misappropriated.